Any mention?
Lordship, I beg to mention item number 21. Lordship, the learned TSGI is having some personal difficulty.
The?
Lordship. Learned TSGI is having some personal difficulty.
What personal difficulty?
Some difficulties, Lordship.
Becomes very difficult to adjourn. The 21.
21 to 23, these are connected matters.
Who's the
Lordship.
other side?
Lordship, we are appearing on day.
Yes. What to do?
Personal
When?
on personal grounds.
Yes. When?
Lordship, after 2 weeks, Lordship.
2 weeks. 21, 22. Okay. Yes. Yes.
Well, there are three matters: 21, 22, and 23.
Okay, 23.
These are
Okay.
all three.
Right. Yes.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship.
Dokken Rava.
Yes, Your Lordship.
Your father side.
Yes, Lordship.
I'm praying for 2 weeks' time, Your Lordship.
Why?
We need some more time, Your Lordship, to prepare, Your Lordship.
Two?
To prepare in this matter, Your
How to
Lordship.
prepare? Okay, 2 weeks. Yes.
Much obliged, Your
Much
Lordship.
obliged.
Lordship, beg to mention item number 32. Conducting counsel and Khera, Lordship, for respondent 3, 4, and 5 is out of station.
Objection.
30. You for the
Respondent number 3, 4, and 5.
number 2, 32.
Yes, Lordship.
32.
Yes. How much? 2 weeks?
2 weeks time, Lordship.
Yes.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 19, Your Lordship.
Where's Mr.
I have informed them, Your
Hashim?
Lordship.
Oh, who's there, bring?
I come along or something. 19.
Why?
Due to some personal difficulties, Your Lordship.
1 week, okay.
Much
This
obliged.
matter will dispose of this.
May I please, Lordship?
Number 18.
Yes, Lordship. Some accommodation, Your Lordship, for 2 weeks.
1 week, yes.
2 weeks, Your Lordship.
Why?
It'll be 1 week,
Some
my lord. It'll be 1 week, my lord.
1 week is old matter.
Okay, Lordship. Highly obliged.
In this code 2020 is a old matter, yes.
Your Lordship, I beg to mention item 29 and 30.
Who's the petitioner?
For petitioner, Your Lordship.
Here there?
Yes.
Your Lordship, here we're awaiting the report, Your
From the
Lordship.
DC?
Yes, Your
That's taking
Lordship.
too long.
Your Lordship, I
After 1
pray
week.
for 4 weeks' time, Your Lordship. They
4
said
weeks'
that they
time?
will complete the exercise within the 4 week.
2 weeks,
4
2
week
weeks,
period.
no, 4 weeks, no. After 2 weeks to enable the learned GA to obtain specific NSC instructions.
Let it be 3 weeks, Your Lordship.
Why? You'll have
Your Lordship, they said that they'll complete the entire exercise
Oh,
within
it's
the
not been
period.
complete.
No, Your Lordship.
Then let it be 4 weeks then, after 4 weeks.
Obliged,
Obliged,
Your
Your
Lordship.
Lordship.
Your Lordship, I
Able-
have a similar prayer for item 26.
26
Your Lordship,
billion.
here the forensic report is being awaited.
Forensic report?
Of the phone, Your Lordship. The phone was handed over just on the last date, Your
Oh,
Lordship.
okay. Yes, after 2 weeks, yes.
Obliged, Your Lordship.
Lordship, I beg to mention item number 28. Conducting counsel P.K. Tawari is not feeling well, Your Lordship.
He's on holiday.
No, Your Lordship, he's
They
not
asked
feeling
for
well.
a specific date today.
Yes, Your Lordship, he's not feeling well.
After 3 weeks, yes.
Highly obliged, Your Lordship.
I've been requested by Mr. Jha to make a mention of item number 5 on his behalf.
5?
Yes.
In the first part?
Of part 2, my lord.
Part 2? 5?
Yes, item number 5 of the hearing list.
No. How did 5 come in the hearing list?
Oh, I'm sorry. I'm sorry, my lord. It's not in this court.
Something happened when you woke up in the morning, yes.
Lordship, I beg to make a mention of item number 34. I pray if no matter can come after 2 weeks, my lord. 34 and 35 are connected matters.
Where's the petitioner? Yes. You have no objection? Yes.
Duly right.
Lordship, I beg to mention item number 31. On behalf of Miss Ain, her treatment is extended.
For?
Miss Ain's treatment is extended because of the severity of her condition. Kindly accommodate.
2 weeks.
Obliged, my lords.
Yes.
Supplementary list. Item number 1.
Well, it's, towards the last orders passed by your lordships, the orders passed by the commission have been filed with the honorable court.
Where's Mr. Pandey?
Yes, my lords, I am there.
He's here.
Yes.
Well, I am now given to understand that the chairman of the commission has been appointed the day before yesterday.
Who's the chairman?
Some Mr. Mondol has been appointed as the chairman.
From where? Has he assumed office?
Not yet. The order
we
has
can't
been passed.
record that, that means.
The formal order has been passed by the governor.
Yes,
My lord, I'm not aware. I have to take instruction on that.
If your
Otherwise, my
lordships
friend
have
is
the
away.
matter,
My lord, sir, I have also been given to understand.
Yes.
To understand that NSCRC has appointed a chairperson, but formal orders in respect, I have been told that formal orders will require at least a week or two.
the order has been passed. The order has been passed, my lords. I have a copy of the order passed by the honorable governor. If your lordships have it a little later, my lords, I'll have the order.
Okay, end of the board.
End of the board.
Item number 2.
May it please yours. It's a contempt petition, my lord.
Yes. After it's been filed?
Yes, the reply has been filed, my lord. In reply, 3 grounds, my lord. One,
Yes.
that they are saying that they are not bound to comply with the order. Why? Because all directors have not been implemented. Let me.
Raising a question of maintainability of the present contempt.
I will address all 3. I'll address all 3 grounds,
I would have
my
to
lord.
first take your lordship to the objections that have
This
been
is my petition, Mr. Paul. Let me.
But I have raised an objection with regard to the maintainability of
I will address everything. So what is being said, my lord, in the affidavit? If your lordship will say, I'll take your lordship to the first affidavit. Paragraph 4, my lord. Are directed against claimant company, Mrs. Marbanyan Project Private Limited. It is well established in law that cases instituted before the courts are subject to dismissal if necessary party is not included in the proceeding. In this case, present application filed by petitioner suffers from misjoinder of parties as claimant in the arbitration proceeding is respondent company. Thus, current contempt application before this court which fails to impede the board of directors of respondent is liable to be dismissed. So, first ground that all board of directors have not been implemented, and therefore on this ground the contempt petition is not maintainable, my lord. Second ground, my lord, paragraph 5 is that, my lord, that it is the contempt petition is not for recovery of money, my lord. Third ground is, my lord, that the proceeding, the arbitration proceeding is pending and therefore interim award is not liable to be implemented, my lord. Fourth ground which has been taken, my lord, is 27.5, my lord, paragraph 7, my lord. No, it says that the answering respondent state that though an application under 27.5 of Arbitration Act appears to have been preferred by petitioner before learned arbitral, no order indicating approval or grant of such approval has been annexed by petitioner in the instant case, the case which only establishes the inadequate compliance of section 27 of the Act. More so when the reference by learned arbitral tribunal is pending consideration, there has been no order in the regard by the court till date. It is stated that there is already a reference pending before Honorable Chief Justice. Until decision in this regard is taken on the reference, there was no requirement on the part of petitioner to file the instant application leading to multiplicity proceedings. So these are, and fifth, 8, my lord, has referred to chief. So this is 7 and 8 is one same ground, my lord. So my lord, first thing first, my lord, first ground is that there is a order passed by the arbitral tribunal. Your lordship, kindly see the order of the arbitral tribunal.
Where is that?
That is at page 9, my lord, which is the order dated 19 February 2024. An application is filed against respondent state of Meghalaya, praying for initiating contempt against the order against the claimant for non-compliance and disobedience of the order of 8/11/2023, read with order dated 10/11/2023, passed by this tribunal. After constitution of this tribunal, an application was filed by respondent number 1 under section 17 of Arbitration and Conciliation Act 1996, praying for interim direction, including security payment of lease rental amount which is not paid by the claimant despite being in admitted possession of the subject property. When the said application was filed, notice was issued to the claimant. On the said application, claimant filed a reply to the said application. Thereafter, application was taken up on 8/11/2023. When the counsel for both the parties were heard, on conclusion thereof, an order was passed on the same day, that is 8/11/2023, whereby application was allowed and detailed order was passed, which includes the following paragraph. Paragraph 4. However, since it is an admitted position that the claimant is in possession of the subject premises and there is a huge claim of non-payment of such dues towards rent for a long period, we deem it appropriate to direct the claimant to deposit and pay the entire admitted and contractually fixed rent of the subject premises to the respondent number 1 effective 7th June 2022, date of issuance of notice, and to 31st 10 2023, along with all government taxes and dues within 6 weeks from today, that is on before 20th December 2020, for which receipt shall be granted by respondent number 1. So far as period prior to period from 1/10/2016 to 6/6/20 is concerned, and which is subject matter of counterclaim, claimant shall furnish a bank guarantee of amount of 2 crore in favor of respondent number 1, which shall be made valid and operative till disposal of arbitration proceeding. We consider this amount of rupees 2 crore for which bank guarantee is to be furnished is reasonable and equitable. It is only 50% of the claimed amount of the respondent number 1. In our opinion, this order protects the interest and equity of both the parties. Said order was modified to an extent by issuing subsequent order of 10/11/2023. Despite the aforesaid order and direction contained therein, claimant has failed to abide by and comply with the said direction order. This is in spite of the fact that para 4 of the order, it was specifically mentioned that compliance of the direction should be made by 20th December 2023. Since the claimant has failed to comply with the aforesaid direction, respondent number 1 has filed the present application praying for taking action against claimant in terms of prayer of the application for violating and disobedience of the order of this tribunal. We have heard the learned counsel for parties on this application today. Counsel for the claimant on instruction received from the managing director of the claimant company, Sri M.T. Marbangyan, who is personally present in the proceeding today, stated that claimant is unable to comply with the aforesaid direction of the tribunal for some reason. In our considered opinion, the stand taken by claimant cannot be appreciated, and we feel that non-compliance of such interim order passed by tribunal, including direction to pay lease rental amount as due and payable, despite being in admitted possession of the project property, is in total defiance and disobedience of the order of this tribunal. The effect of this order on the arbitral proceeding will be considered at the later stage, but at this stage we are of the considered opinion that proceeding under Contempt Sub Court Act is required to be drawn up against the company and the person responsible for running the claimant company. Lordship, against the company and the person responsible for running the company. Kindly mark these 2 lines, my lord. Since the tribunal does not possess the power and jurisdiction to take action under Contempt of Court Act, yet we feel that this matter would require a strict action, and therefore contempt proceeding.
Why did you file it then when there is an order that the place for registration of a...
Your lordship, the remedy I have it in law, my lord. There is a...
You have to bring notice of the court.
To court, so this is the way we have brought to the notice of the court. Ultimately, your lordship has to see the end of the justice. There is an order passed by arbitral tribunal under section 17. Now, under section 17, direction is there. You pay the lease rental.
Okay,
you are in possession, and
an abject violation.
And then, if there is a violation, my lord, ultimately I put a question to myself. If violation is there and violation is writ large, my lord, on the face of it, the objection which is being taken up that the matter has been referred and therefore this 27(5) application is not maintainable because matter has been referred by the arbitral tribunal. So what my friend is arguing is that there is no remedy to the aggrieved person only as and when the matter is brought before this. Let me finish. I have not finished my argument because you will argue 4 points and you say 27 points. So first point is, my lord, would your lordship consider this egregious violation of the order of the tribunal? Otherwise, what is the point of passing of the order by arbitral tribunal? And this issue, my lord, for this issue specifically, I place that judgment on last date of hearing rendered by Justice Nariman, where in that case, where Honorable Supreme Court said that it is this 27.5 is meant for punishing the contemner of, because Your Lordship, the parties have two remedy, my lord. They can come under section 9 before the commercial court, my lord, and section 17 before arbitral tribunal. The question arose in that case whether if the order of the tribunal is not bound to be obeyed and there is a violation, then section 17 will become OTOs, my lord. In that context, my lord, the Justice Nariman, in the case of Alka Chandar, said that judgment is, it should be part of the file, my lord. You have extra copy? Yes. Yeah, I have extra copy also, my lord.
Oh yes, sorry.
Lordship, kindly see section 27.5 at page paragraph page 123. It is quoted, my lord.
Yes.
5. Persons failing to attend in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceedings shall be subject to like disadvantage, penalty, punishment by order of court on the representation of arbitral tribunal as they would incur for like offences in suit and tried before the court. If section 27.5 is read literally, there is no difficulty in accepting the plea of learned senior counsel for the appellant because persons failing to attend in accordance with the court process fall under a separate category from any other default. Further, this section is not confined to a person being guilty of a contempt only when failing to attend in accordance with such process. This section specifically states that the person guilty of any contempt to arbitral proceeding during the conduct of arbitral proceeding is within the ken. The aforesaid language is in fact in consonance with the chapter heading Chapter 5 Conduct of Arbitral Proceeding. Further, it is well settled that a marginal note can be used as an internal aid to interpretation of statutes only in order to show what is general drift of the section. It may also be resorted to when the plain meaning of section is not clear. In the present case, we must go by the plain meaning of subsection 5. This being the case, we find it difficult to appreciate reasoning of the High Court. Also in consonance with modern rule of interpretation of a statute, the entire object of providing a party may approach the arbitral tribunal instead of the court for interim relief would be stultified if interim order passed by such tribunal are toothless. It is to give teeth to such orders that an express provision is made under section 27.5 of the Act. In fact, Delhi High Court by judgment of 18/8/2009 reported in Anand has correctly construed 27.5 of the Act. Further, it must be remembered that in Ambalal Sarabhai Enterprise versus Amrit Lal has held that parties to arbitration proceedings are put an election to whether they to apply for interim order before tribunal under section 17 or before court under section 9. Such election would be meaningless if an interim order passed by arbitral tribunal were to be written in a water, as all parties would then go to the court and which would render section 17 a dead letter. So, my lord, this matter, this judgment, my lord, is clearly on the issue of contempt of the order of the arbitral tribunal, my lord, and even the High Court judgment has also held, my lord. So the question which falls for your lordship's kind consideration is what? Admittedly, in the reply, the petitioner has not, the contemner, alleged contemner has not given any reply as to disobedience, willful disobedience of the order of the arbitral tribunal, my lord. There is no, once there is an order, my lord, otherwise the sanctity of the entire process, because your lordship has seen that the time was given to the contemner to comply with the order up to December 23, my lord. They are admittedly in possession of my property. They are using my property. They are not paying the lease rental for last 5 years, my lord. It is a government property, and in government property, there is an order, right or wrong, this order is there. If my friend has some grievance, he could have challenged or he could have taken resort to some other process. But ultimately, it is a rule of law, which he cannot be stultified by saying that the directors have not been implemented as party. The order is clear, company and managing directors. Second point which my friend has taken under 27.5, if reference has been made, only the reference is pending, and 27.5 gives the power to the party also to approach the court, my lord, on this ground.
Yes.
And on this ground, contempt is your lordship within the roster of your lordship, and contempt, my lord. So this is the second ground which has been taken, my lord. On this technical, hyper-technical, I would say, my lord, and is also not on the face of it maintainable. A bare reading of 27.5, my lord, would show that has been interpreted in Alka Chandra, my lord, and in Alka Chandra also, my lord, and in both the cases.
Yes.
Lordship, even in 27.5, my lord, if I take your lordship to section 27.5, 27 itself, my lord, court assistance in taking evidence, my lord. Arbitral tribunal or a party with the approval of arbitral may apply to the court for assistance in taking evidence. The 2 is the application shall specify, my lord. 3 is court may within its competence and in accordance with its rule the evidence. 4, court may while taking order under issue same process. So section 27, 1 to 4 is concerning taking evidence. 27.5, my lord, person failing to attend in accordance with such process, my lord. So this can be brought to the notice by this honorable court either by arbitral tribunal or by the party concerned who is aggrieved, my lord. Is the process is bringing to the notice of this honorable court violation of the order of the arbitral tribunal, my lord. If I read, my lord, persons failing to attend in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt to arbitral proceeding tribunal during the conduct of arbitral proceedings shall be subject to like disadvantages, penalties and punishment by order of the court or order of the court on the representation of arbitral tribunal as they would incur for like offences in suits tried before the court. What we have done, my lord, we have brought to your lordship's kind notice that the violation which has been committed by the party, and this violation is writ large or on the face of it. If my friends are...
What about them taking shelter of the...
yes, they cannot saying that the reference has been made, therefore only reference can be taken, my application cannot be taken. That is what my friend is trying to argue, my lord.
What about the order of the division bench?
A division bench, my lord, is with regard to recovery. We are not seeking, in contempt, we can't seek recovery, my lord. Can I seek recovery? This is...
So what does the order say? That division bench
in that order, if your lordship will see, the order also, my lord, it is in the context where the recovery was filed in the garb of contempt petition. Recovery was basically in that context. Page it is there at page 7. Your lordship will see very short order of the counter, my lord.
So distinguishable.
This is because we are not seeking recovery, my lord. My prayer is not recovery. For recovery, I have to go in execution, my lord. I will go in execution. And 6 also, my lord. 6, your lordship, the ordinarily, it is not, the contempt jurisdiction cannot be invoked to enforce payment, particularly against a private writ petitioner. The petitioner was entitled to enforce against responding in accordance with law, nothing should be prejudiced. Ordinarily, my lord, when there is a contempt and willful, if the contemptor is not going to purge the contempt, my lord, I have seen the lordship has not heard the contemptor, my lord. Because first contemptor has to purge the contempt. And what is the contempt? Is willful disobedience of the order of the arbitral tribunal, my lord. This is the plea which is taken, my lord. If I take the argument of my friend to be correct, my lord, then in that case no contempt petition is maintainable by saying that it is for recovery, or your lordship's orders are for number of things, my lord, and what your lordship see in the contempt proceeding is whether the order is being complied by the party or not, my lord. They have taken more than 10 dates, my lord, in filing reply. And reply what they say that I will not comply with the order. I will not comply, I will not follow the order. Arbitral tribunal is the order which is to be put in the waste bin, and party has got no remedy in law, and the argument is accepted, then 27.5 will become OTOs, my lord. And this contempt petition, what my friend is saying, that this contempt petition should be dismissed because the matter is pending, proceeding is going on before, and he has more claim.
Yes, Mr. Paul. Oh, you finished?
Malaj.
Sorry.
If my friend is done, Malaj, I can begin.
Yes, we have. Yes, I'm done.
Malaj, first I would take your lordships to the prayer made in this contempt petition and how it is being turned around before your lordships now. Page 7, Malaj. Why the order of the division bench would hold the field.
Yes.
Well, your Lordship would kindly see in the interim
Yes.
at page 7, my lords. Be pleased to freeze the bank accounts of the contemner and or any other step to ensure the amount is deposited before this honorable court in compliance with the orders dated 8/11/2023 and 10/11/2023.
Yes.
So this is, my lords, basically arm twisting me to pay,
Yes.
which, my lords, has been held by the division bench, cannot be maintained in a contempt proceedings.
Yes.
The pleadings are set forth, my lords. The learned Advocate General has argued at length. Let me just take him through his own pleadings at page 5, paragraph 8.
Yes.
My lords, may I read para 8? It is submitted that in terms of the order dated 8/11/2023, the alleged contemner was directed to make the requisite payment on or before so-and-so. However, it is submitted that the alleged contemner neither made payment of the rent of the subject premises nor furnished the bank guarantee of rupees so-and-so. Then para 9, my lords, it is submitted that on account of non-payment of the pending dues of the petitioner herein was constrained to file an application under 27(5) to seek approval of the learned tribunal to initiate contempt against the proceedings against the claimant for disobeying so-and-so, so-and-so, so-and-so. Then, my lords, at para 11, if your lordship kindly see, this is the most important one, that it is submitted that despite unequivocal direction passed by the learned tribunal, the alleged contemner has failed to pay the rental to the petitioner. And, my lords, at para 12, they say that it is submitted that non-payment of the pending dues will cause irreparable loss to the state and will severely and irreversibly impact public interest by financially prejudicing the state. So it is essentially a recovery proceeding. Now, I'm not here to advise my learned friend, my lords, but the Act itself makes provisions for execution of orders passed by the tribunal, and that is not by initiating contempt.
Yes.
My affidavit before your lordships at this stage, my lords, has only dealt with the maintainability of this present contempt proceedings in the way it has been filed before your lordships.
Yes.
That's number one, my lords, and your lordships are well aware. It was a very same matter, my lords, where my learned friend was appearing for the respondents, I was appearing for the petitioner. There were certain directions passed by, my lords, the division bench. When those directions were not complied with, they filed a contempt application and that judgment came to be passed, which your lordships have already perused, that for recovery of amounts, my lords, or forcing somebody to make a payment, contempt proceedings are not the appropriate remedy.
Yes.
Because the remedy is available under the Act. They could have invoked that, my lords. They choose not to invoke that. They come before your lordships and file the contempt proceedings.
What about order of the arbitral tribunal?
I'll deal with the orders of the arbitral tribunal also, my lords. Your lordships may kindly come to para 11, page 11, para 5. Now, what happened is, my lords, they filed an application. Your lordships have just read that. If your lordships kindly have a look at para 5.
Yes.
How does the arbitral tribunal deal with that application? The tribunal says, my lords, since this tribunal does not possess the power and jurisdiction to take action under the Contempt of Courts Act, yet we feel that this matter would require a strict action and therefore the contempt proceedings to be taken up by the Honorable High Court Meghalaya. Well, this almost is like a direction to this Honorable Court, which, well, I would take I'd take a pause here without saying anything further. Then they say, my lords, that we therefore refer the matter to the registry of the Honorable High Court for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. So, my lords, the reference is already made by the tribunal for the Honorable Chief Justice to act as per his own wisdom, as per law. It is not open for the petitioner before your lordships to bring in a second action of contempt by way of filing
this matter placed for registry? Any instructions? Was this placed for the registry?
My lords, it is for them to reply because the next line asks them to place it before the registry, whether they've done it or not, or whether they chose to file this application.
My lord, this petition is by way of bringing the notice to this Honorable Court, and this is addressed to the registry, the Honorable Chief Justice only.
It is absolutely absurd.
Your lordship, kindly see the petition.
This is registered as a contempt application.
Yes, this is my lord, kindly see. This is addressed to the Honorable Chief Justice only under Section 12 of the Contempt of Court Act, my lord. We have brought everything.
No. See, we therefore refer the matter.
Yes, my
It's not a
lord.
question that you are directed to
Either,
please the
my lord,
matter.
the mode.
Refer the matter to Registry in Honorable High Court.
How do we
Please
refer?
the
The
matter.
question is, my lord, how do we refer? By way
My lord,
of
my
their
lord,
mode.
the
What my
tribunal
friend
has
is questioning
referred.
is the mode of reference.
lord,
Mode of
may I
reference.
just
The
finish?
manner
My
of
friend has
reference,
had
my
to
lord.
say.
Manner of
May I-
reference
may I
in
just-
my
may
humble
I just
submission
argue?
Let him
is section
argue
12.
this. You're both talking at the same time. Yes.
May I just finish, my lord? My learned friend would have a few other things to also answer to. My lord, there is a reference. There is a difference between initiating a fresh proceeding and a reference. A reference is by a lower forum before a higher forum for your lordships to adjudicate that matter, and matter has to go before the Honorable Chief Justice.
Yes.
For the petitioner to now come before your lordships and say that by way of filing this application, my lords, we have brought it to the notice of the Honorable Chief Justice because simply it is written that it is addressed to his lordship, the Honorable the Chief Justice, my lords, is an absurd proposition.
Yes.
They were directed to place those matters before the registry, my lords, and the registry would then register the matter individually as a reference. Now, in the teeth of such directions, my lords, this application is there before your lordships for initiating contempt under section 12.
We will do one thing. We'll place this before the Chief Justice.
My lords, in my humble submission,
Let me
this matter
answer.
has to
Let me answer what my friend has raised,
Your
my lord.
lordship-
What
Yes.
he-
No,
my
if your lordship, if I may just finish to the,
Yes.
the preposition that has fallen from your lordships, my lords, that would also, in my humble submission, not be the correct thing to do. The reference by the tribunal is already before the registry, my lords. That would have to be registered as a reference and placed before Honorable the Chief Justice.
Whatever it is, we'll place before Chief Justice. If there's a reference pending, then they'll be taken together. That's it. But from what has come out, that means I think apart from technicalities, it deserves a contempt notice for contempt proceeding initiated.
My lord.
Yes. Otherwise, what's the point of arbitral tribunals passing interim orders or interim awards if it's been blatantly being violated by the parties?
My lords, the other aspect
That
of the
is-
matter is that
You're looking at a larger
instead
picture.
of-
Other picture, you're looking at suppose put yourself
My lords,
on the other
my
foot.
lords, my lords, these are commercial proceedings.
Yes.
These are commercial proceedings.
Exactly.
There is nothing on this.
That's why commercial proceedings deserve the least amount of interference. That's it. By courts. They should be allowed to take their own way. I mean, like whatever recourse they have to, they
My
should
lords,
be given
exactly,
a...
which is why I submitted before your lordships, my
Yes.
lords, that the remedy is available under the Act.
Yes.
The remedy is available
We'll
to
do
them
that,
under
yes.
the Act for
I heard
enforcement of the orders of the
for
tribunal.
parties, Mr. K. Paul, Senior Counsel, on the challenge to maintainability of the instrument petition, has drawn the attention of this court to the order dated 19/2/2024 passed by the Learned Arbitral Tribunal in arbitral proceeding number 1 at 2022. It is submitted by the Learned Senior Counsel that the matter, the petitioner is not at liberty to initiate the present or to file a present contempt application in as much as
Last line of page 12, your lordship will see.
as much as the
Would
arbitral
not be
tribunal
construed as a fetter on the right of petitioner.
had placed the matter for reference to be placed for Chief Justice by the registry. Stop do objections next that have been raised by Learned Advocate General in view of the order passed by arbitral tribunal. Place this matter before the Learned Chief Justice for consideration. Yes.
Obliged. Obliged.
You can make same submissions there. Yes.
Item number 3.
Obliged.
My lord, I'm slightly handicapped today, my lord. If your lordships can have it tomorrow or sometime next week, my lord. Next week, my lord.
Yes, Mr. Bora.
Tomorrow, not possible. Next week is okay.
Why? You're going to Dhemaji?
Yes, ma'am. Not Dhemaji, actually.
Well, that's always excuse you give. I'm going to Dhemaji, so.
Dhemaji is
after 1
next
week.
month. Next month, 5th, ma'am.
Next month, you're Dhemaji, okay.
Yes.
Daily list item number 1.
This is, my lord, delimitation issue, my lord.
Yes.
And
it's not completed as yet.
it is going to be completed. I saw in the newspaper yesterday that it will be completed within this month or something.
I am under instructions, my
KCDC
lords,
will
that the
be
petitioner does not wish to pursue this matter any further.
Okay. Mr. K. Paul Leonard, Senior Counsel at the outset, submits that on instructions, the petitioner does not wish to pursue the matter any longer. Accordingly, matter stands dismissed as withdrawn. Yes.
Item number 2.
Please, Your Lordship. Your Lordship's wide order dated 19th June, Your Lordships has disposed my application of under Order 7211.
Yes.
Lordship, the issues have to be framed now.
Have you framed issues?
Issue only is with regard to presentation, my lord. We are required to file a list of preliminary witnesses.
File your list of witnesses?
Lordship, for today we are having some difficulty. I have
Handicap.
adjournment, Lordship.
Mr. S. Deb.
Only grant 2 weeks time.
Prays that 2 weeks time be granted. Tell them to as file an application seeking time to file certain issues along with list of witnesses. Yes, prayers allowed. This after 2 weeks. Yes. We'll file it, then let them file it. I'm still interested. Very much.
Item number 3.
Otherwise, they'll die natural deaths.
May it please your Lordship. Lordship, pleadings are complete in this matter. The matter may be posted for hearing. I'm appearing for the petitioner.
Parties submit that the pleadings are complete, that the matter is for hearing. Accordingly, list the matter for hearing on so and so.
Item number 4.
Please, my lord. My lord, the matter may be posted for hearing.
Where's your other people?
Stay response. A moment, my lord.
Oh, moment?
A moment. Item 4 and 5 are connected.
Yes, you're here? No.
Your Lordship.
Yes. Where's the...
Well, I won't be filing any rejoinder.
You're not filing rejoinder? Mr. CCT Sangma submits that no rejoinder is necessary in the instant matter. He prays that the matter is for hearing.
3 weeks, my lord. 3 weeks.
Yes. Accordingly, it's a matter of hearing after 3 weeks.
4 and 5, my lord, together.
4 and 5.
Okay.
Item number 6.
My lord, we are yet to file affidavit here, my lord. I'm praying on behalf of Mr. Bhattacharjee, my lord. Just
He's an expert in dodging. Oh, he's here, see.
he is here, my lord. He'll be in a better position, my lord.
What is this? You undertook to file within 1 week, you said.
My lord, on last occasion I stated, my lord, but however there are some changes, my lord. If my lord
1 week is 7 days only, Mr. Bhattacharjee.
My lord, some changes and some annexures are also missing, my lord.
Further 1 week's time granted to Mr. K. Bhattacharjee to file affidavit.
Can it be 2 weeks, my lord? So that I
2
file
weeks
it.
time.
File, my lord.
Item number 7.
My lord, items 7 and 8, counter affidavit has been filed, my lord, but this is with regard to issue pertaining to regularization, my lord, under section 3F, my lord. Some legal issue is involved, my lord, because the candidates have failed in the examination. They appeared and they failed. In the first round, writ was dismissed, my lord. In division bench, division bench passed the direction to dispose of the representation. What I saw in the file that a formal order has not been, file noting is there, but a formal order disposing of the representation is not there in respect of 5, my lord. So kindly give me some time, my lord.
You have to come a fresh petition. What's your prayer here?
They've challenged my advertisement, well, again.
Okay.
Advertisement which is a...
Have you filed affidavit?
Affidavit has...
Well, we are also awaiting instructions, well,
4 is yet to file, Your Lordship.
You want to file additional affidavit?
Yes, my lord, I want to file.
Mr. A. Kumar, Advocate General, prays that on behalf of the respondents number 1, 2, 3, and 5, pray that they be allowed to file additional affidavit in as much as the question raised involves the issue raised involves the question of law. How much time?
2 weeks, my lord.
Accordingly, 2 weeks time is granted. Similar praise made by the
Respond number 4,
for list after 2 weeks.
R4. Valid. Obliged.
8 is connected.
Item number 9.
It is correct.
May I please, Lordship?
Yes.
Lordship, I've received the counter affidavit, Lordship, of all the three respondent, Lordship. I would like to file my rejoinder affidavit, Lordship.
Okay,
2 weeks time may be granted, Lordship. 2 weeks time.
Praise funds allowed 2 weeks time to file. Rejoinder affidavits filed by the respondents.
Right, Lordship.
Interim order is there? No.
Oh, yes, Lordship. Interim order may be granted.
Yes, interim order when he shall continue the next day.
Oblige, Lordship.
Item number 10.
May it please your Lordship? Lordship, I'm praying for some more time to file a counter affidavit, Lordship.
Yes.
In this matter.
You are for?
Respondents
5, 11, 15, 17, 19, 20.
Lordship.
1, 2, 4.
We.
And who's MR Marak? You are Mr. Sheikh, 12, 16, 18, 21.
12, 16, 18, 20.
Have you filed affidavit?
No, sir,
Why?
There is some more time, Lordship.
Your Lordship.
2 weeks time.
State's file.
State file.
Your Lordship, if we may file a rejoinder to the state response.
Do that all affidavits come? They file together?
Oh, okay.
So they can come for hearing? Yes. Stop. MS Cruz for respondents number 5, 11, 13 to 15, 17, 19, 20, and Mr. S.A. Sheikh for respondent 12, 16, 18, 21. Pray for a further 2 weeks time to file affidavit. Stop. MS Arcoli submits that affidavit we have 1 to 4 already on board. This after 2 weeks.
That should like.
Item 11.
Your Lordship, the respondents are yet to file their affidavit, Your Lordship.
So I'm praying for further 3 weeks' time on behalf of respondent 3 to 16, Lordship.
Where's 1 and 2?
1 and 2.
I'm appearing for.
You're 1 and 2.
Yes, sir.
All the same club. 1 and 2 and 3 to 16. Yes, further 2 weeks time.
Your Lordship, there is an interim order also, Your Lordship.
Interim order shall continue to next date.
Obliged.
What's the matter? Nokma matter?
Fine of 500 imposed by the village court.
500 rupees fine.
Yes.
You come against that.
They are come against the non-compliance of that.
You have not paid the fine.
Appeal is pending before the subordinate district council court. Lordship.
You pay the fine 100 rupees. How much is they paying you to appear here? 100 rupees only or less. Then.
Item number 12.
Yes.
Lordship, item 12, my lord.
They have been seeking time to contact the client, my lord, repeatedly.
You can't contact them.
No, we have Lordship, if I may just place my case, Lordship. Here, what has happened is a contract was entered into by the company petitioning company and MEPDCL for the purpose of installing substations as well as upgradation of existing substations in 13 to 14 locations, Lordship, in East Garo Hills. Now, the contract was entered into in the month of December 2020, and the period for completion of the work as per the contract was a period of 18 months. However, Lordship, as per the contract, terms of the contract, they were required to pay the advance first for us to start the work. That advance was paid in the month of May 2021. And as per the contract, the period of completion of the contract
months.
would start thereafter, Lordship. So we had time till July 2023 or so. Now, Lordship, what has happened in the meantime, Lordship, because of the various factors, including the delay of payment, COVID, and other issues, practical issues, Lordship, the work was slightly delayed on our part, as well as because of their attitude in delay in releasing the payments and so on, Lordship. Now, first show cause was issued to me, Lordship, in the month of.
If my friend is arguing on merit, my lord, kindly see the order of 24th April, your lordship, 2024.
No, that we have.
Your lordship, the order has to be corrected,
Yes.
and it has not been corrected. For that purpose, instruction is being sought, and now he's.
We have corrected, Lordship. Kindly see page 216A and B. We have inserted it in the.
So then it should come. It should come in the order that they have corrected.
Yes.
They have obtained the.
When they
instruction.
corrected?
When did you correct?
Before the next date.
Because no, they have been seeking instruction.
What does this see? The council correct the defects. So a next order.
Also
instruction.
And then on 6th of May on the motion when it
Next
came
order
up for
6 is a
motion.
request. This is petition tomorrow. Petition tomorrow. Please follow wanted week term of pre-instructions. Why you didn't inform the court? When did we correct it?
Corrected. That is the order. It has to come in the order, my lord. I went through the.
in the order sheet. In the
No.
Because we are required to correct it. So
In the order sheet, it should come, my lord.
Oh yes, yes, come here 1-5.
Immediately.
It has to be placed in the order, my lord, that the petitioner has corrected the because it is in the judicial order.
You should have
because
apprised the court that you done
corrected. So that I will also be having because I thought that it has not been corrected, my lord.
So let it come up tomorrow, my lord.
Let it come tomorrow, my lord, because in that
tomorrow.
Case, after week also, after week.
Or Monday,
after a week.
Monday.
No, Monday is slightly held because Supreme Court is opening on 8th July. So.
Now, if I may, if that is only one prayer, lordship, at this stage, now my bank guarantee of around 6 crores is
has been encashed.
Not yet been encashed. So there's
first day he has to
establish the next date if the bank guarantee may not be
because
you
first
have
I had
bona fides,
first
question that you have not
3 dates they have.
If the clause is there that if for your infractions that the encashment is to happen, will happen.
Lordship, only till the next day, till Monday, my lord.
Your lordship, because they know, because they have taken 3 dates, my lord. Ultimately, these bank guarantees value will be gone. Tomorrow.
Obliged.
This is matter tomorrow. For orders.
That correction may be noted, my lord. That correction is
Mr. S. Deb submitted that the corrections as allowed by this court by order dated 24 April 2024 since been complied with.
Yes, ma'am.
Call this is matter tomorrow for the orders.
Obliged.
Item 13.
Please, Lordship.
Yes.
Matter is fixed for filing of counter affidavit by the respondent.
By whom? By
2 and 4's Nehu.
Number 1's whom?
Union.
Number 1 is not the necessary party, it's a formal party only.
Number 1, who are you?
Union of India.
I'm praying for some more time to file my affidavit for 2 and 4, Your Lordship.
Why?
This is the second time, Your Lordship.
2 and 4?
Yes,
2, 3 also? Registrars there?
2 to 4, Your Lordship.
What's the matter about?
Lordship, for
non-people per year of salaries.
Yes, Lordship.
Mr. Armajan, we have 1, 2, 3 principals allowed further 2 weeks time for affidavit. Yes. Stop. Mr. Ardebnath submits that no affidavit forthcoming from the respondent number 1 as they are just formal parties. Yes.
Item 14.
Lordship, I seek 2 weeks time to file affidavit.
Where's the petitioner?
On behalf of Ms. Assign.
This is regarding the non-payment of the money for completion of the contract, Lordship.
2 weeks time as prayed, allowed for affidavit is listed after also.
Item 15.
Item 15, I need times to file my affidavit.
It's a fresh matter.
Yes, sir. Further 2 weeks time granted to the responsive affidavit just thereafter.
16.
Service complete. On behalf of? There's only one party respondent. Yes, Mr. Philemon Nongri has entered appearance today on behalf of number 5. As such, notice on all the respondents is complete. What about affidavits?
My Lord, we are still awaiting instructions.
Mr. K. Varsaji for GA for 124 submits that yet to receive instructions. The principals allowed 2 weeks time to file affidavit. Similar prayer made by Mr. Philemon Nongri for 5. List after 2 weeks. Yes.
17.
The notice had been sent by registered post on 2nd July, so return will take some time. Maybe listed after 2 weeks, my lord.
What about signed counsel you've given or not?
Sent by registered post, my lord, to all.
Officer indicates that notices on 2, 3 and 4 yet to be service report or officer indicates that service reports not received for 1, 2 and 4. This after 2 weeks of service report.
Second call. Item number 1, supplementary list.
Yes, Mr. Paul. What is the name of the?
His name is Mr. Chandan Kumar Mondol, my lords. He is the ex-director commercial NTPC Limited, my lords.
Okay.
The appointment order is dated the 2nd of July, 2024.
Yes. So, in this matter, this is for disconnection.
Yes, my lords.
Only one problem there, Mr. Paul, you already disconnected yourself by your own admission.
My lords, we just stopped.
How do we reconcile that?
My lords, we stopped running the plant. That would have the effect of not consuming electricity. My lords, that the paragraph is not happily worded. I had submitted already before your lordship, my lords. Because the supply is from the MECL to us, my lords. Even though it's written as I have disconnected, my lords, I cannot disconnect. I can only stop consuming. That's what I can do.
That may even, my lords, amount to a misconduct under the regulations.
Non-consumption may not be a misconduct, my lords, but
non-consumption.
if I tamper with the lines, yes, definitely, that would be a different issue altogether. But I don't think that is the case here, my lords. It was only an issue of not consuming electricity anymore.
What about the fixed charges? Are you liable or not? We don't consume.
My lords, under the regulation, I am not required to pay the fixed charges once that they allow it. But what they said is, my lords, you pay the dues, then only we will allow that.
No, question of dues, that 10 crores is impossible. That cannot be allowed.
That is the
only thing.
That is, my lords, that the outstanding dues are reflected in the bill. But what we were asking for is the fixed charges which they have to pay. Under
the regulation, I'm not required to pay the fixed charges.
No, but you disconnect yourself. That means that after disconnection, in accordance with law, then you don't have to pay fixed charges. But if you've done it unilaterally, then you are liable. So the thing is that maybe we can pass orders that they cannot demand for payment of this outstanding, and you pay only the current charges. And
current bills are all up to date, my lords. I have a chart here with me. We've paid the entire current bills are up to date. There's not a penny outstanding.
Mr. Pandey, we'll listen tomorrow. You take instructions that the court's inclined to pass directions that you cannot insist on this Annexure 6
the
bill.
Differential amount, my lords.
No, my lords. As far as the payment of the electricity dues is concerned, the electricity dues of current consumption is being basically sought from the petitioner. But as far as the previous dues is concerned, Bilals, what we are saying is that we are not seeking a recovery as of now because the matter is pending before the MSCRC.
Exactly. That is what.
But my lords, what my submission is that as far as the pendency of the dues is concerned, that, my lords, cannot be construed as some sort of a stay for other benefits that the petitioner is trying to seek under the regulations. For instance, my lords, temporary disconnection or load enhancement. So if that amount is, my lords, disputed, then it is disputed, my lords, both the sides will be in the same position as far as that disputed amount is concerned.
See, Mr. Pandey, to the understanding of this court, is that the petitioner seeking disconnection temporarily because he wants to undertake some servicing repairs of the plant. Correct? That's number one. Now the thing is that the application has been made, but instead of saying, okay, fine, like these are dues payable current charges in view of the other tariff which still to be reconciled or decided by the commission, will allow you disconnection, but now you saddle him with the bill of undecided amount. That's the only controversy here. And the only part which is on their part that they have gone and disconnected themselves. So for that, they'll be liable also. It has to balance out. Yes, what do you want to say?
Oh, I would say, my lords, now that the chairperson has been appointed, my lords, in MSCRC, both these writ petitions, my lords, in light of the initial order passed by your lordship on 15th of February 2024, my lords can dispose of both these petitions asking the MSCRC to decide both these, the special tariff, the main matter, within a time frame, my lords.
That's not subject matter here.
That is not the issue here. That's not the issue here.
Yes. They can make a passing observation, but it's not a direction. The only thing is that what will you do with pending matter here?
So, my lords, then they have to, as my lords, I had earlier submitted, they have to raise the issues as far as the electricity bill is concerned before the CGRF. That is the law, my lords, which has been laid down by this honorable court, my lords, on multiple occasions. The electricity bill, my lords, cannot be disputed
Your
before
lordships have passed an order on contempt.
Yes. Yes.
So, my lords,
Some orders have been
alternative
passed by your lordship on consent of both the parties. Can somebody be allowed to take a U-turn on the consent?
No, there is no consent as far as the stay on the outstanding dues is concerned. The consent order, my lords, had been passed that the matter has to be expeditiously decided.
Orders passed by the lordship.
So neither, my lords, they have followed the regulations as far as temporary disconnection is concerned, and nor have they approached the appropriate, my lords.
Page 22 is the order, my lords.
Page?
Page 22 is that order, my lords. Passed by page 22, my lords, your lordship's order. Paragraph 3, my lords, last part.
Yes.
If I may read, my lords.
Yes.
1, 2, 3, 4 lines from the bottom of para 3. With regard to the tariff collected by the petitioner corporation as well as the special tariff paid by the respondent consumer herein, the same shall be subject to the final adjudication by the Meghalaya State Electricity Regulatory Commission. Admittedly, my lords, the matter is pending. You cannot insist on payment of any of that amount, my lords, for any request that is made by the petitioner.
That
That's
the
the
court
limited
understands,
case of the
you know,
petitioner's
that
before your lordship.
we accept your submission on that part. Only with regard to your own disconnection, then whether you be liable to pay fixed charges for the amount till, you know, the disconnection is done. That's all.
Well, let them decide on that. Let them decide on that.
They dispute the amount also.
Bills, I can
They have to pay,
I can make a
You have to
statement. I
pay.
can make a statement before your lordship, Millers. Insofar as my current dues are concerned, it is paid up to date. There's not a penny outstanding.
I have some other instructions below.
As a matter of fact, what I can do is, my lords, I have a chart made. I can supply a copy to my friend Mr. Pandey, and
Where's
we
the
can
chart?
seek instructions whether there is any amount due on account of current.
You take instruction by tomorrow. You have answered the mind of the court. Take instruction by tomorrow. And even for your unilateral disconnection also, that you'll have to...
Then have it on Monday, Millers.
Okay, Monday.
Because it cannot be possible to get the...
This is matter for the order on Monday.
Monday may be...
Okay,
Millers,
Tuesday.
may I pray for Tuesday? Millers?
Tuesday 9th, yes.
Obliged. Well, item number 4 of the supplementary list is connected with the same issue.
Hearing. Item 24.
Obliged.
Yes. So does he discharge duties in the school?
My lord has directed me to take instructions on those two things, my lord, that whatever she has submitted, my lord, the other day before, my lord, these were, my lord, maintained by herself, which is not even to our knowledge, my lord. And the routine, that 2023 routine that was shown to my lord, that is also, my lord, that is one routine which was never acted, my lord. Of course, because at that relevant point of time, as we say that she was...
How will you decide that then is one word, is her word against yours?
My lord,
her word, I mean the
my lord,
teacher's word against the school's word.
My lord, this is the teacher's attendance for the entire 2023, my lord.
This is your document.
Yes, my lord. This is our document. This is an
Never
official.
end. You take that money.
Yes. Therefore, my lord, we have given her a very...
You take that money.
Yes.
And your lordship, I pray if the actual amount may be paid to me, your lordship. That's the...
You take the money because the thing is that, look, whatever happened, they had been arrangement before. They'll pay you for a whole amount you work at 5,000. Plus
Yes.
how much?
We have so far paid to her 3 lakhs, 4.8, something like that. I'll just confirm. But apart from that, my lord, even if she is not teaching, we'll calculate to her monthly 5,000 and we'll pay to her.
That'll come to how much?
My lord, we'll have to calculate, my lord. We'll have to calculate and pay her, my lord. We'll pay her.
your lordship, I'll just pray, like, if your lordship can pass to order at least 10,000 amount, your lordship.
Well,
that at least that much they can consider, your lordship.
They'll give a check to you in court next date.
My lord, yes, my lord. We will calculate
You
and
take it, otherwise we'll pass orders.
Yes,
because
Lordship.
it's,
Obliged,
Mr. P. Obin submits that we are allowed to compute the amount payable to the petitioner.
Yes, my lord.
Which is objected by M. Your side. We'll finish it off. No sense in
Yes,
prolong it.
yes, Your Lordship.
You're not doing legal. Is it legal aid case? No.
Legal aid cases, yes. No, this is not a legal aid case, Your Honor, but it's just like pro bono, Your Lordship.
Very good.
25.
Obliged, Your Lordship.
Lordship, in this matter, the private respondents had filed their affidavits. We have just been served with a copy.
Who's the private respondent?
On Monday or Tuesday. Private respondent.
Mr. Bhattacharya.
You are appearing?
I'm appearing.
Why you filed so late?
No, they filed in 23 apparently. We were just served.
2023?
Lordship.
We filed it on 7/3/2023.
Why are the private respondents here?
Because their pay had been stepped up because they are the petitioner.
Do you have any claim?
Yes, because we are the same grade. They are the junior official, junior employee, junior employee.
Relief against them?
No, not against them. Against the state. They are challenging that there is a disparity.
No, he wants his scale to be stepped up.
Lordship. And we are saying that his scale has been stepped up on 2 occasions.
No, because in their
which he has not disclosed in his petition as well.
No, Your Lordship, in the rejoinder affidavit, Your Lordship, that they themselves has already make a statement that fixation of pay scale revised up to.
Rejoinder affidavit? Who filed rejoinder?
I have filed it. In the affidavit, they also have enclosed in their affidavit in opposition.
Mr. Sen's asking for time.
Lordship.
Listed on
Next
after
week.
1 week is.
Lordship.
Mr. Sen submits that the affidavit filed for respondents has just been served upon him.
Lordship.
As he has just obtained copy of the, not served, Mr. Sen submits that he has just obtained copies of the affidavit filed by respondent. He prays the matter is up to 1 week. Praise aloud.
Highly pledged.
Much blessed, Lordship.
27.
Yes. Start. Yes, Mr. Paul. Yes, Mr. Paul.
May it please, Your Lordship.
Where we had submitted to the Lordship.
Yes. Yes.
Your Lordship, I pray if this matter could be taken up in the next state, Your Lordship, since the conducting counsel is not keeping well.
Who's conducting counsel?
As a general.
And yes, we will never do the hearings as it is this 4-round adjournment, second round again of, formal adjournments. When?
Week's time, Your Lordship.
It has been submitted that Mr. S. Jindal, the conducting counsel of the respondents, is unwell. This is not up to 1 week. Yes.
Much obliged.
33.
Yes.
May it please, Your Lordship.
Yes.
Lordship, this is that Nehu matter where we've challenged the appointment of respondent number 6 and 7 to the post of.
1 second.
Before my learned friend started,
Lordship.
I'll seek some accommodation, Your Lordship.
Why?
But I am having some, my lord, throat infections. Lordship can just...
Mr. Sen has a throat infection. You can't argue today.
Just, my lord, I'm just 10 days time, Your Lordship.
This matter has been adjourned repeatedly.
No, not at my instance, Your Lordship. This is the only time I'm asking.
As after 1 week, you please be available. Yes, as Mr. Sen has expressed his difficulty due to throat infection to conduct the matter, list this matter after 1 week. 1 week.
Obliged.
Like this to
Obliged, Lordship.
Obliged.
36. 36.
Please, Your Lordship, I pray for...
Finish the matter, yes?
I pray for week's time.
Why?
Never all the other matters.
Your
Conducting counsel is not here. Actually. Conducting counsel is unavailable.
Who's conducting counsel?
Mr. N. Singhon. And I just receive a affidavit filed with a.
You all totally disabled the court. I mean, what is, you know?
My lord, fix it on Monday then.
Don't you have to justify a salary?
My lord, no, it's
At
not
least
for salary, my lord. My lord, it's a transfer, my lord.
Transfer petition?
No, my lord. It's a. Yes, my lord.
Order he has come.
My routine transfer was stayed by the director, my lord, on the very next day, without assigning any reason, my lord. That I have challenged, my lord, before this.
What to do? Where's Mr. Singhon? You have the brief with you?
My lord.
Do you have the file?
I have to file.
You have?
I have to file.
Lord, kindly fix on Monday, my lord. Because in 23 matter and it's transfer matter only.
And moreover, I just receive a affidavit filed with a private respondent.
We'll let it next week.
Yes, as the conducting counsel on behalf, praise been made on behalf of the conducting counsel for the state whose unavailable lists next week is. This is really first round weekly lists are made, first round adjournment large scale, this court very liberal.
Yes, my lord.
And then when a hearing taken up, the adjournment is taken again. What's the point?
My lord.
You might as well just give a list. We'll make the list and you submit the list to the court master that you don't want to do this case, and that's it. Sometimes court reads the files also, like this. Yes, like it just, you know, good judgments come from good assistance.
Correct, my lord. My lord is correct.
And also, if lawyers are very keen and very, to do matters, then that gives court some. Now, you'll make me do some interest.
Yes, my lord. And it affects the mindset also. When
the mindset
prepare,
affects
yes,
even if relief is supposed
prepares
to be
the
given
entire
to
case.
they're not, lawyers themselves are interested in getting relief. So what are you going to do? They're not interested in getting relief. Clients giving you the brief.
Yes, my lord.
All hope, that the matter will be disposed of quickly.
Yes, my lord. True.
Yes.
Obliged.